Good morning, everybody. Welcome. We are going to take a deep dive today into installment sales. Now, you know who it's going to be. Our favorite attorney is back, Bruno, and as always, he has brought his power team with him. So, guys, this is an extremely important session. Take it in, make notes, because this can really generate you new business down the line. So, Bruno, the floor is yours.
Thanks so much, Nicolene. Thanks again, guys, for inviting me. Always such a pleasure to present to everyone. This is actually a topic I feel relatively passionate about, reason being that it wasn't all that popular up till a couple of years ago. And I still remember one of the first presentations I made on this topic, where we started just playing around with it. No one knew anything about it. And we just started messing around, asking a couple of questions, trying to see if it worked. And yeah, it turns out it's an absolutely fantastic tool for property purchases. So guys, thanks so much. I really hope you enjoy this. And yeah, let's maybe get the ball rolling. There's a lot of content to go through, and then we're making time towards the end for a Q&A. So first and foremost, for those that haven't attended any of my presentations, my name's Bruno. I'm an attorney. I've been an attorney now for I think since about 2005, 2006. I focus predominantly in the property space, but in the commercial space, so making money, investments, developments, that sort of thing. My background's actually in litigation, so I started out dealing with disputes, evictions and sales, and developers fighting with landowners and that sort of thing. And subsequent to that, I've been focusing a lot on tax, because I find, especially with property investors, tax structuring and that sort of thing is very important. And the lovely lady to my left in the slide is Alicia. She's property specialist in the conveyancing department. She's like basically my right hand when it comes to conveyancing and registering these type of contracts. Alicia, do you want to pop by and say hi?
Hello, how are you?
I'm good. You well?
I'm well, thank you. Thank you for everyone having me here. It's great to be here. Hope I can teach you all something. But it's going to be Bruno that's telling all the knowledge and giving all the knowledge. So I'm happy to be here.
Do you want to introduce yourself a little bit more than I have?
Okay, so I finished my LLB, I think in 2017 at UNISA. I was admitted as an attorney in 2019, notary in 2020, and a conveyancer in 2021. So yeah, and I've been with you guys for I think almost 2 years now.
Cool. Okay, so just so you guys, in case anyone wants to know, these are some of the affiliates that I work with very closely. But yeah, just to kind of cover what we're going to discuss today, I'm going to try my best stick to these times. It's not always possible because sometimes we get carried away with one thing, so we need to cut something else short. But we're going to try to touch all the exciting topics. I'm just going to start off with the commercial fundamentals. So it's an introduction, but it's more about creating the spirit or the purpose of an installment sale agreement. I mean, why are you guys here? Is it just something you should know, or is it something you can actually work with? Is this a tool? Does it have commercial feasibility? And if it does, what does that actually look like? What does it compare to? So this first section is actually going to be quite important. I gave it 20 minutes, but I feel I might go a little bit over on this section, but you're going to see why. And the first section is actually going to be quite nice to kind of get your heads around what it's all about. Second section, so this is more like a SWOT analysis. So you'll see that the second section deals with strengths and weaknesses. So we're going to deal with fear. So once you get this first section and you understand why it's important for you to know what you can actually do with it, how you can use it as a tool to benefit yourselves as agents, Then we move on to the second section, which starts dealing with the red flags. So now this goes back to that skills development, going, okay, but how do I speak to the seller about it? How do I speak to the purchaser about it? What does it actually entail, aside from the broad understanding that we have, and then the opportunities and threats? So the third section is actually pretty cool. So over here, we're going to go back into commercial feasibility and start asking ourselves, well, what can we actually do with it? Where will it work? Where can we plug it in where our conventional mechanisms don't work? So we'll speak about that. I'll give you a bunch of different options and alternatives that look similar, that do similar things. And then we'll have a conversation in the Q&A. I'm actually excited to get into a conversation about how you guys can actually secure commissions through these alternatives. Like, what does that actually look like? What would the mandate, how would the mandate need to read? Because now we're changing the landscape. We're giving you like a weapon in your arsenal that you didn't have before, but now you also need to make sure that you like support it. You've got enough to go on so that, you know, if it comes down to suing for commission as an example, you don't get caught with your pants down. Right, so first things first, and I'm going to bring Alicia in as I discuss a couple of things. As I go through each slide, I'm going to bring her in. Alicia, obviously, if you have anything to add, feel free to interrupt. That's totally fine. And yeah, add your input. Right, so first things first, sorry, I'm just removing, there we go. All right. So first things first, what is an installment sale agreement, also known as an ISA? And is it the same as seller finance sale or rent to buy agreement, right? So this is a very practical notion. That's why I'm bringing it up. A lot of people in the property space speak about seller finance. Oh yeah, you know what, we'll just get seller finance. What does that actually mean, right? Is an installment sale agreement seller finance? Is this what we actually mean? Or is it more rent to buy, right? Sorry, just one sec. I just need to move the slides. There we go. There we go. All right. So is it more like a rent to buy? So let's maybe take a step back and kind of construct it. So installment sale agreements. What is an installment sale agreement? It's nothing fancy. It's installment sale agreement. If you wanted to buy whatever, a car, a cell phone, anything, and instead of paying the purchase price at once, you paid over a period of time, that's an installment sale. You're paying it as an installment. You're still buying, but you're deferring the payment. And we use the word defer quite a bit because that is the legal word behind it. Defer just means instead of paying everything at once, you pay it over a period of time. That's simple as that. So anything, whether it's a car, whether it's a cell phone, whatever it is, very often you guys would enter into installment sale agreements. You want to buy it right now. So this differs from a rent to buy as an example, right? A lot of rent to buys or a lot of hire purchases or things like that deal more with leasing something over a period of time, and then possibly at the end of this lease being able to take ownership. A lot of this actually sounds more like an option as an example, and I'll touch on this later, is where you lease, but you have an option. And if you exercise that option, you get it at a special price that's already discounted or something along those lines. So more often than not, that is what we'd call the rent to buy. It's actually a lease agreement with an option to buy versus an installment sale agreement, which is more about actually buying and just deferring the payment of the purchase price. So how do these wrap into seller finance? Quite simply, it's seller finance because the owner, the seller, is effectively financing the sale. They're giving you the ability, they're giving you credit. So the same way that a bank would normally say, here's money, pay it to the seller, and every month you're going to be paying me back. Now, what you're actually doing is you're doing that, but with the seller, not the bank. So that's why we refer to it as seller finance, because the seller gives you that credit. They give you that opportunity. Now, seller finance is an umbrella term, right? All of these things are seller financed. Why? Because the seller gives you that opportunity. So if you do a rent to buy, to a certain degree, that is seller financed. The seller is renting the property out to you. They're giving you an option to buy it later at a good price or a fixed price, but they're obviously going to prejudice themselves. That is seller finance. Seller finance here, installment sale agreements. There's even a couple of other seller financed options that I'll touch on later. So that is the concept of seller finance that sits as an umbrella term, and one of the main tools we use is the installment sale agreement. So Alicia, is there anything that you want to add to that?
Bruno, I actually think you basically covered it. It's very well explained, and I do agree. It's more the seller finance is an umbrella term, and it kind of differs with the rent to buy agreement. So I don't have anything else to add.
So commercial sense. So now you guys understand what's an installment sale agreement. It was actually quite a simple explanation. Probably didn't need 5 minutes, but you got it anyway. So commercial sense and commercial feasibility. So why are we speaking about it? I mean, you as an estate agent go, screw it. You know what? The guy must go to the bank. He must get a bond, and he must buy the property. But that's not always possible, right? There's a commercial aspect behind this, and this is where you're going to start seeing that as estate agents, if you're able to construct deals in this way, you're going to open up the possibilities of the amount of property purchases that you're going to have in your hands. Because what's the biggest issues agents face at the moment, right? Now, there's two components to an agency. There's the canvassing, getting a property. So that's very difficult, right? But that is a marketing thing. I mean, you guys need to get out there. You need to be live. People need to want to give you that mandate, right? You need to have that proof of concept. Can you sell their property at the best possible price? That's all you, right? But when you go out and you start finding these purchases, the one problem is sometimes it's not the lack of purchases. I've noticed depends, area dependent, property dependent. But there's certain sweet points with some properties where that you're going to get interest. It's not the interest you're worried about. It's actually being able to get these guys to complete the sale. Why? Because they can't get bonds. Or if they get bonds, it's 90% bonds, and there's a 10% shortfall, or 80% bond with a 20% shortfall, or they're buying through a trust, or they're buying through a company, and the banks are being difficult and they don't want to finance them, or there's some issue, they are foreigners and the bank's only willing to give them 50% or 0%, and they have cash, but they can only pay a little bit of cash now, a little bit of cash later. Commercial feasibility means that now you guys can make that choice. If you know that you're going to sell this property and you know that the guy's going to get a bond, sure, you know what, go for it, right? But if you think you can sell it for more to somebody else, if you think that you're going to lose this mandate because the mandate period's now expired, the sole mandate's expired, this property is going to go to other agents, and you need to find a way of making it work. Trust me when I say this. This has worked wonders with all the agents across South Africa that I've worked with, because it is a Hail Mary. It's basically coming in with one last option and giving the seller one last option just before something else happens. They go on auction, the bank forecloses. This is where it starts making commercial sense. Now, how can you take advantage of this? If other agents don't know this exists, they're going to keep using the same conventional means to try sell their properties. What we're doing is we're giving you another option. We're giving you another little weapon. Whether you want to use it at the beginning or not is your prerogative. But now you have it. And it's something you can use to make sure you get that deal across the line. And how do you secure your commission? And this, I think, I'll also bring you in on this, Alicia. So there's no one simple answer. There's so many ways of securing your commission, but that shouldn't be your first thought going, oh, I can't secure I don't want to do it. There's ways of doing it. Start thinking around the ways of doing it. Alicia, have you had any experiences with commission and securing it in installment sale agreements?
Yes. So I actually have a very good example that I can give to you. So we did an installment sale where the purchaser, I think he took occupation of the property, not actually living in the property, but taking occupation, having a tenant in there, paying the rates and taxes, paying the levies. At that stage, he couldn't qualify for a bond. So that's why we registered the installment sale agreement, and he took occupation, so paying rent, basically not paying off the purchase price as yet, just having it registered. Then when it came to that stage where he actually had to apply for a bond or start making the payments, he couldn't. So we did another addendum to extend that period for him. In that sense, in that installment sale agreement, there was actually an agent involved as a deposit that he paid and that he could actually afford at that stage. I think it was like 30,000 Rand. That was also taken in the installment sale agreement to say, okay, that can be paid out to the agent already, and that is as part of the purchase price. So they agreed on that. In the meantime, he couldn't, as I say, get a bond. He couldn't make the payments for towards the purchase price, only the occupational rent, the rates and taxes, and the levies. He is now at that stage where he actually resold the property, got his purchaser got bond finance, and he's now using that bond finance to actually secure the one where his contract is recorded, making it a linked transaction. And in that sense, the agent could also have still been involved, which it isn't in this case. But if the agent knew, okay, but my purchaser also wants to actually link the transaction and resell, he can try and get another purchaser and also gain commission there. So that's just a perfect example of how this makes sense to actually also sell it to your client, especially if the purchaser cannot immediately, wants the property, but cannot immediately start paying the purchase price or get bond finance.
And it's funny you say that, because we did an investor webinar for Century 21, must have been like a couple of months ago, 8-9 months ago. And we discussed these different options because unfortunately, if like flips, for instance, I've dealt with a lot of agents that aren't fans. You know, as soon as they touch it, they get worried because it's like, oh, but the guy, he might mess around and now they need to go find another purchaser. Well, why can't we just go find another purchaser if they're going to sell it for higher anyway? And I know a lot of agents that have worked it and gone, oh, you want to flip it? No worries at all.
Double commission.
Double. And over here with installment sale agreements, it's exactly that. So the one worry with the conventional sale is you go, here's an offer, but it's subject to. So now the agent goes, you know what? I don't want to do it because they're going to try and find another purchaser. And if they don't, it's subject to, and there's a mess, and now I don't get com. With this, you get your com. So it's great. You know what? Installment sale, for 5 years' time, there, I get my com, right? Now, let me help you go flip this property. We'll do stuff to the property. I'll advise you, and I'll go find you another purchaser. Double comp without the risk of a suspensive condition, because now the investor's like he's committed. He's signed a contract. And how to secure the comp, I normally suggest is, guys, so installment sale agreements, you might have installment sales where people don't want to pay a deposit. I get that. But
we were lucky in this instance, sorry, Bruno, that it actually worked out that the both parties agreed the deposit will be used at the commission, but there is a lot of people that don't agree with that.
Exactly. No, exactly. But in a case like this, and remember, if you're trying to get this ISA across the line and the agent controls the process. So the situation we often experience is the other way around, where you have a savvy investor. They happen to find the property through an agent, but they control the whole process where it almost feels like the agent's being dragged behind them and finding it difficult to set terms or control mechanisms because these guys are going off at a tangent and this agent's just desperately trying to claw on to some sort of commission securing. Versus the other agents that we've trained with ISAs, where as soon as they see the possibility or somebody mentions it, they control it and they go, fine, we can do it, but it's going to require 2 installments up front of X amount of money that's going to be released as such, or 1 big deposit, or whatever, right? And I get my commission up front because obviously you as an agent, you've got choices. You can either secure your commission today, and you can say it's a 80,000 Rand first installment that comes straight into my pocket, or you can do it as an annuity. And you could actually honestly, so I don't know what internal policies are. I'm not saying that you can do it internally, but what I've seen some agents do is because of the deferment, they actually increase their com by a little bit more, and they go, well, I was charging you 4.5 because I was giving you a discount, but now I want my 7.5 back. But I don't mind collecting it over the period of a year. So every month an installment comes in, I take a portion, and the risk component, because I don't make it all today, is that I've got that little margin at on the back end that makes sure that it's worth my while. I'm deferring it over a period, but I'm getting 2.5% more, 3% more. Many ways of skinning a cat, right? It's there's no right or wrong answer. It's just getting your head around what you want to achieve and how you want to actually achieve it.
The other risk that I was just thinking about as well, with regards to, as you say, over a period that that the purchaser pays it and you get your commission. What if the purchaser doesn't make that payment?
Yeah.
That's also the risk that you're taking on your commission, that you're not going to get that payments that come in installments, basically. Instead of a once-off deposit, you get your commission. Maybe lowering, as you say, by a bit, but you have your commission. Instead of waiting 6 months or a year, but you don't know what the purchaser does and if he's actually going to get finance, if he's going to make that payments, and then you lose out on your commission. It all depends on the kind of purchaser that you have.
Exactly. No, absolutely right. And look, remember, and I mean, you and I have this conversation all the time. The reality is, it's a commercial decision for the agent and for the agency.
Yeah.
In my mind, I take certain risks for a cost. I might do work, for example, for clients, even estate agents. I'll do commission claims for them. But I'll carry a risk component because on the back end of it, I might make money, money at the end or something along those lines. There's always a give and take, I suppose. So here, yes, you're right. Does the agent want the money now? Charge a commission that makes sense. So charge your normal commission and insist that the deposit gets paid. You want a little bit more money on the back end of it, you're going to need to take a risk, because would they be willing to pay the 7.5% initially? Maybe they would, maybe they wouldn't. Would they be willing to pay 8%? Could you go higher and justify it by saying, well, I'm waiting for my commission, so I'm adding a little bit more. Maybe you can charge interest on your commission as an example. Different ways of doing it. We'd have to explore the options, but don't discount them. I think that's all we're saying is don't discount them, get into a flow. And once you're in that flow and you start establishing those habits, then you've got a way of actually making this work for you. So are we on time? Almost 2 minutes late, but in order to move on to the next section. So remember, right at the beginning, I said that we were almost going to do a SWOT analysis of the of installment sale agreements. But before we do the SWOT analysis, we need to get our heads in the right space, right? Because what are we analyzing? There's two things. We're having a conversation with you as an agent and going, is an installment sale agreement beneficial to you as an agent? Forget your seller, forget your purchaser. You as an agent, can you make money from it? I emphatically can say yes. In fact, you can make more money by having it as a weapon than without it, right? I've seen this. It's a real thing, right? So yes, you can. It's commercially feasible for estate agents to know, understand, and promote installment sale agreements as property practitioners in the right space, in the right way, and subject to terms that make sense for everyone, right? Now, as we enter part 2, we're stepping away from wearing the property practitioner hat directly, and we're going great. So now we all agree potentially. I mean, you can send messages on the chat in case anyone doesn't agree, but let's assume that we all agree. Now, the next step is to go, how do we actually use it? How do we convince a seller to say yes? How do we convince a purchaser to say yes? Why would they say yes? And in order to do this, I always discuss these 3 principles. So I've been dealing with property investors for absolute ages, and I've pretty much narrowed down all their needs into these 3 different pillars. It's as simple as that. I cannot really find a need. There's another little pillar called legacy that I sometimes look at. But as an investor, I typically find these three, and that's protecting an asset. When I buy something, when I own something, I want to make sure that it's safe. Financing efficiency. I need to be able to know that I can pay for it or that I can raise money to pay for it. And then tax efficiency. So just keep in mind these three fundamentals, because as we go through the SWOT analysis, it's quite funny how you're going to start picking up that everything that I'm discussing with you is probably going to be something that you're going to be able to relate to a seller and a purchaser under one of these three items. And because they're going to be worried, but what if I lose my property? Here's the answer. The purchaser is going to be worried, but what if he does something to it while I'm paying him off? There you go, asset protection. I've answered your question. Financing efficiency, come on, I mean, it's a given. The purchaser now doesn't need to get a bond. How efficient is that? That's the perfect financing efficiency, because you don't actually need to go find money. The money is right there. You pay it in installments. That's true financing efficiency. And tax efficiency we'll touch on right at the end. Not as popular with installment sales, but there's a couple of things you can do with it. Right, so the next section now, we're going to deal with strengths and weaknesses. So this is common misunderstandings on installment sale agreements, and how do you ensure the best protection for your client. So this section is going to strengths and weaknesses, or what you're going to use to try to convince a seller and a purchaser that this is a good thing, that they should consider it and look at it. Okay, so first thing. And Alicia, feel free to jump in on any of the questions here. So biggest issues or fears are these are the common questions we get. There's not an exhaustive list. There's many others, but I find that this really kind of hits the nail on the head, because the purchaser and the sellers keep asking this. So now you've got a purchaser, he comes to you, let's say he applies for a bond, he doesn't get it. And he says, sure, I really want this property. It's a great investment. I'm going to do a lot of good things with it, but I can't get this bond. I just simply cannot afford it. But I really want it. I've got a plan. I can take occupation of this property. I've already got tenants I can put in there. I want to start the rezoning process, whatever it is, right? You know, can I pay it off in installments? Will this guy be willing to consider me paying this off over a period of time? So now you run to your seller, right? In fact, what I'm actually going to do now, I'm going to give you an example. Let me give you a scenario. And then I'm going to try base all the following topics on this scenario. So this is a real life scenario. It's one I personally did, myself and one of my business partners. So there was a property in Sunninghill in Sandton. It was a really nice property. It was relatively old, a lot of stuff that needed work, but the guy was in financial distress, which is where already you start getting that little red flag going. Installment sale could actually work. At that moment, I had no interest going to the bank applying for a bond. Obviously, as an entrepreneur, the banks always like make you jump over so many hoops that sometimes just not worth it. So I was like, no, screw it. You know what? I'll do it as an installment sale because I see that money is going to come in and I'm going to be able to pay this thing off very easily. We did an assessment over the property. So the owner, as it stood, was not utilizing the property properly. It had the potential of having two earning capacities from, I think one was from tenanted space if it was set up properly, and the other one was actually advertising space, because there was space for advertising on the property. All you needed to do was get your consent, and you could actually advertise to the streets and charge money for it. So we knew this because we'd been doing properties in that area before, so it was very easy for us. We just saw it and we were like, knocked out, hey, listen, we want to buy from you. This is the income we're probably going to get. We're willing to pay you your full bond installment, your property rates, obviously consumption charges. We're in occupation. And on top of that, we're going to pay you a little bit extra. So we're going to pay X amount. I think it was around maybe 20% above those amounts. So that would not only cover all expenses on the property, but would give a little bit more for the seller to pocket. And all these amounts in our negotiations, bear in mind, it's our negotiations. This isn't the right way necessarily of doing it. In our negotiations, all these amounts were going to reduce the purchase price. So where we were getting away with a really good deal is that we weren't paying rent. And that's something that you have to bear in mind, that if you're trying to make the deal work so that it makes sense and you're looking out for the seller, you might want to factor in rent. So we didn't have to. Why? Because our upfront payment was going to be about 300K. So we took 300K cash and we're like, you're in financial distress. So we are willing to give you 300K, but the rest of it, we're going to take our time and we're going to pay it off. We're going to put the tenants in. We're going to get the money in, keep a little bit and pay you off. We were making money. We were actually profiting from the monthly installments. He was getting his purchase price reduced, so he was covering it. And on top of that, he had 300,000 Rand cash to pay off his debt, which is where the pressure really, really was. So that's one really cool scenario that I worked with before in the past. So you as an agent, now imagine that you are the one that put this together, that it wasn't me, because you can do exactly what I did. You're a property practitioner, so you understand the principle, so you're right there. So what if the purchaser stops paying? That's common fear number one. What if the purchaser stops paying? Now the seller sits there and he's not getting any money anymore. What's going to happen, right? Again, depends on the circumstances. If the seller is still in occupation of the property, then it really isn't that bad. Then you cancel the contract, put it up on the market. It's almost the sale as it's almost the same as a normal deed of sale. If the purchaser lands up taking occupation of the property, it's the same thing as a normal deed of sale. Sometimes you guys sign deeds of sale, people move into the property, and then the contract gets canceled and you need to evict them. Guess what? It's the same thing. I'm not saying there's a good answer to it. What I'm trying to say is, does it really make that big a difference? Is it worth tanking a deal because of that when these risks exist either way in any contract that you enter into? So is there a possibility the purchaser stops paying? Yes. Is it the worst thing in the world? No. If the purchaser's made any payments, including a deposit, you can write it into the contract that you can start utilizing this deposit to cover costs, to cover an eviction, to cover whatever. So factor it in. If the seller is really, really that worried, factor in a cost that's forfeited, an amount that's forfeited entirely for the seller's benefit to make sure that all their risks are covered. Alicia, I know you've dealt with this type of situation before in the past. How did you guys get around it?
So I actually want to speak more about part 2, about what if the seller simply sells the property to someone else behind my back, but we'll get to that now, obviously. With a purchaser that stops paying, in the installment sale agreement, you obviously have a clause in, just like with a normal deed of sale, that says if someone is in breach, you have to place them on terms. If they then still don't perform, you can then, as the owner of the property, then apply for the cancellation of that contract. So there is still, it's the same with the normal deed of sale. If they don't pay a deposit or whatever the situation is in your deed of sale, you place them on terms. So that still needs to be in the installment sale agreement. Actually, if you don't mind, Bruno, I see Lance here actually has a question, and which is maybe good to approach now, on what is the difference between an installment sale agreement and a deed of sale. So it's very important for you guys to actually know that the installment sale agreement basically puts out the terms, and please jump in if my description is terrible, Bruno. So the installment sale agreement puts out the terms over a period, saying every 2 months you'll pay 100,000, or whatever the terms is of you paying that installment sale the whole time. That contract is also with the application registered in the deeds office against the property. Where the deed of sale is just a normal offer to purchase. I'm buying a property now with a bond or cash, or bond and deposit, and we do the transfer documents, we get the rates clearance, and the transfer is then registered in the deeds office. Where the installment sale is just noting that installment sale agreement against the property, but not yet taking transfer.
Yeah, no, absolutely. You got 100. It's exactly that. I know that your second point. So sorry, you wanted to get to that second point because you were mentioning recording. So maybe tell us a little bit more about the recorder.
That is the fear that most of the people have, especially the purchasers. But what if the seller just goes and sells it again? I've been paying my installments, and then you think litigation, and everyone is just freaking out.
So this is a purchaser fear.
Yes, this is a purchaser fee, and we have dealt with that before. So the seller cannot simply just go sell the property to someone else. The reason why an installment sale agreement is recorded against the property is when we as conveyancers go, we get an offer to purchase and we see, okay, the seller sold the property now to whoever. We do a deed search. On the deed search, it shows the owner of the property details, and endorsements. So at endorsements, it will note if you have a bond over the property, and it will also note a Section 20 contract to say, listen, if your purchaser is not this person, you can't transfer that property. We need to cancel that first, and then you need to approach the purchaser before you can just cancel it. So it's not easy to just transfer to anyone else, because that contract is basically securing, or how can I say, making it safe that the seller can't just go and sell the property, because as soon as it gets to our table, we'll see, but it's not the same purchaser, and we can't then actually sell it on.
So I mean, it's not technically speaking an interdict, but
No.
it almost acts like an interdict where
Almost acts like it, yes. I can't, because I need to deal with that endorsement first before I can actually transfer the property. And because that endorsement is there, that endorsement says I either need to transfer it to you if you have the installment sale contract registered against that property, or I need to cancel it first before I need to remove that endorsement. And the only way I can remove that endorsement is if I cancel the contract.
So just for the sake of context, so that everyone understands. So the reason this exists is, remember, South Africa is a very consumer-centric society, and correctly so. You might disagree, and I disagree with many different aspects of the law. Sometimes I feel it's a little overly consumer-centric, and it takes the rights away from suppliers or landowners or that sort of thing. In this particular instance, I get it, because buying a property in installments, especially when you look at the way that RDP houses and things like that are dealt with in South Africa, it does cause a lot of confusion. It causes massive fraud, where people are selling now based on an affidavit that they signed at a police station. The person forks out 50,000 rand, 100,000 rand, thinks they own the property, and 20 years down the line, there's 20 guys claiming that they bought it from each other, and they've each have this affidavit, or these trees of affidavits, right? Now, why this is important? Number one, South Africa has a pretty good deeds registry system, right? You'd be surprised. We complain and moan about South Africa a lot, but the reality is we at least know the property that we own, right? For a property to be deregistered out of our name is a process. Now, it's not to say it doesn't happen, but in fairness, it happens everywhere in the world where fraud is committed. So if somebody's going to steal your identity and sign documents on your behalf, that's not a South African thing. That's an international thing, right? The deeds registry just makes it super difficult for stuff like that to happen. We need to keep records of things like this. It's fantastic that we've got the ability to buy a property and keep records of it, so that everyone knows that we bought it. This is a very consumer-centric provision. So the recordal is there for the most part to protect the purchaser. But why? Because the purchaser's been paying money, right? Now, the seller still owns the land. They actually still have this tangible asset. But now the purchaser's been paying money, and if the seller now decides one day to walk away and unlawfully terminate, it lands up in a situation where now you need to go to court and all of this. Registering this contract the way that Alicia explained just gives peace of mind to a purchaser, because now he's willing to pay that money. He's happy to pay it because it's not that big a deal. In fact, we don't have time to discuss it today, but if you go through the legislation that governs this, not only are they happy to pay it, but they've got the option of paying it directly to the bank. They actually have the right to claim from the bank statements whenever they need, in order to show that, in order to prove that the money's actually been applied correctly. They're allowed to see what amount is outstanding at any given point in time. So this has been integrated to such a degree that the purchaser can part with his money and feel very little risk or uncertainty by doing so. So that's pretty cool. And then number three, What if the seller passes away? Alicia, do you have any thoughts on that?
I would love if you can explain that one, because I have not had that and I don't want that, but it's probably going to be the estate stuff, and there I do not get involved with.
Okay, so when a person dies, so for starters, there's a lot of confusion sometimes when it comes to death and insolvency, right? It's, I bought a property, transfer hasn't taken place. Oh no, somebody died or they're insolvent now, everything's going wrong, right? Now you have to distinguish between these two different principles. Death by itself, right, does not necessarily do anything to a contract under our normal common law. So unless the legislation otherwise specifies, under our normal common law, you're entitled to enforce a contract as against an estate. Obviously, if it's a services agreement, that's not going to work because an estate's not going to be able to provide the same service. But typically, when it comes to the supply of products or goods, there's nothing wrong with enforcing it. You signed a contract and the estate is bound by that contract. So they have to give you this asset. So take that aside and go, if the seller dies, where does the purchaser stand? The purchaser is good. The purchaser is entitled to that property and they're perfectly fine. They can keep paying 100%. Now, the bankruptcy, and that's point number 4. Bankruptcy is where the issue starts coming in. Now, under normal circumstances, if a person dies and is bankrupt or is just bankrupt, so we refer to it as, you'll hear sequestrations or liquidations or whatever the case is, they're all the same thing. They mean bankruptcy. It means I don't have enough money to pay my debts. At any given time, my liabilities are more than my assets and I can't afford to pay, right? That's bankruptcy. So what happens if you buy from a seller that's bankrupt? Now, the beauty behind this is that by entering into this contract, you actually get a degree of security. You become a preferred creditor. So that's number 1. That's a great place to be in, because sometimes you buy a property from conventionally and transfer takes 3 months to get go ahead. And during that time, the guy's declared insolvent and you're actually in trouble because now you've paid amounts. Sometimes the seller actually accrues these amounts with some of the investors I work with, and now the monies are gone, or you've started renovations on the property in the meantime, thinking that it's yours, and now the guy gets declared insolvent. With this specific contract, the beauty behind it is you get a right to this property. So the insolvent estate can come to you and say, okay, listen here, he's insolvent now, but you're entitled to pay the rest of the amount and you can take the property, right? Now, that doesn't happen under normal insolvency. Under normal insolvency, a liquidator or a trustee can actually repudiate the sale. So if you enter into a normal contract with anyone and at a given point in time they're insolvent, a trustee can walk away and say, sorry, I don't want to perform in terms of the contract. Sue me if you have to. With this, they don't have the option. They have to give you this property at the price you paid, provided that you can pay it all at once. So it's not a question of continuing paying in installments. You probably have to come up with a bond and pay it all at once, but you can get away with that. So that's a really nifty right that doesn't exist elsewhere in our law. Then what happens to improvements if the sale is cancelled? The contracts, and again, the legislation actually provides for this. If you attended to necessary improvements or maintenance or repairs, so necessary expenditure, you can't actually contract out of that in this contract. In terms of the legislation, you're entitled to claim it back from the seller. If something goes wrong and the deal is cancelled, as a purchaser, you can get that money back. If it's improvements that weren't necessary, but they're luxurious, as an example, in that instance, if you did it with the seller's express consent, you're also entitled to get it back. So there is no issue at all. You can't exclude that. If the seller says you're allowed to do and make improvements to the property, you can claim that back in case something goes wrong. So in these contracts, you typically have something like that that provides for you to be able to get the money back from any improvements if this gets cancelled due to the seller's breach of the contract. So a purchaser mustn't be scared. So this covers, what if the seller passes away? You're good. What if the seller's insolvent? It's all right. You might need to make a plan to come up with the money, but you've still got the right to, you don't get left empty-handed. And if for some reason the property gets sold because you can't afford to come up with the money at once, it's okay. You've got a preference right just under the bank. So before anyone else starts sharing in those proceeds, you start sharing in those proceeds. Can you claim the improvement cost back? Absolutely. Absolutely, you can. And you've got a lien over it under most circumstances. So from a purchaser's perspective, there's a lot of security here. So remember when I mentioned asset protection? This is exactly what I was referring to. As a purchaser, you're good. As a seller, of course you're good. You're still owner, right? You've got the best asset protection because you still own the property. You're getting money as purchase price for property that you actually own. You haven't given up ownership. You don't need much more protection than that. So you're good to go as a seller. And then the last thing is covering the seller's bonds and rates. Should I not have occupation? So this is actually quite an interesting one. And people don't quite grasp it, and only attorneys that have done this before a lot of times, like us, we've constructed this in so many different ways. And it depends on the client. So there's no right or wrong answer. It is going to be a matter of practice. Reality is there's two different enjoyments a person's having here. You're entering into a contract of sale. So you're buying a property. It's a sale transaction. But you're occupying the property. Occupation is a separate right, separate enjoyment. These two different enjoyments you would normally pay for separately. So with a conventional deed of sale, if you buy a property, it doesn't automatically entitle you to occupation. You have to actually specify that you're going to take occupation before transfer. And if you do take occupation before transfer, there's normally a rental amount that becomes due, right? Not in all circumstances. Sometimes the sellers actually want purchasers to take occupation because they live abroad and they want to avoid whatever vandalism to the property, as an example. There's many different reasons, or maybe the property is derelict, so no one really cares about occupation. So they give the guys occupation because they're going to start cleaning it up anyway. So, what does the seller have to do? A lot of good reasons why occupation is allowed. Maybe it's been factored into the purchase price, whatever it is. So the same rule applies here. The only difference here is we're speaking about longer periods of time. So it's more emphasized that what happens with occupation, because this contract has to last more than a year. Remember that fundamentally, this contract has to be longer than 12 months. So that's a long time to have occupation. It's not 2 months or 3 months like a conventional deed of sale. So you speak about a lot more. Because you speak about a lot more, you have to factor it in. There's no rule of thumb. You can do whatever you want. What some of my purchasers have very cleverly done, these are the investor guys, they will take, and it's an interesting little notion, so it's just an idea to work with because I like using it. They will take the purchase price and say that purchase price is at 100%. Occupation, if the purchase price is at 100%, that means that you haven't paid a cent towards the purchase price and you're occupying the property. You have to pay full market rent for this property. So this is the best rule of thumb I can come up with, aside from you negotiating out of this. But as soon as you pay 10% of the purchase price, leaving the purchase price at 90, then your rent should actually be a little bit less, because now in theory, you actually own 10% of this property. No, not in theory, rather, like effectively, you own 10% of this property. So because you own 10%, you shouldn't have to pay that 10% in occupational rent. So you'd pay 90% occupational rent and you'd owe 90%, and so on and so forth. So as soon as you get to having paid 20% of the property value or purchase price, you would pay 20% less in rentals. And you keep doing this until you get to the other end of the scale, where at the bottom over here, let's say you only owe 100,000 Rand on R1 million property, meaning it's only 10% left that you owe, but then you'd only be paying 10% rent of the occupational rent. A lot of my guys do it like this to make it fair on themselves, because if they're paying the purchase price, they feel that they shouldn't have to pay the full amount of rent. Like I spoke to you about in my deal, I was saving the guy to a certain degree. So I negotiated, give me occupation. You're not using the property properly. In fact, you're letting it worsen in condition. We'll come in, we'll fix it up, but then we're going to benefit from it entirely. Here's 300,000 Rand. And he was more than happy to take it. So anything's negotiable. But as a rule of thumb, I normally go down this kind of proportion approach. From your side, is there anything you want to add to these common fears?
I actually just want to state with regards to the payment of the rates or levies or rent and all that. So our rule of thumb is actually that we don't get involved with that calculations, because remember, we assist the agent, or even if it's private parties, to draft that installment sale agreement and the terms and conditions that they want. But when it comes to the finances of it, we do not necessarily have the capacity to make sure we get all the proof of payments for the rates, if that has been paid every month, depending on the terms and conditions, obviously. If the bond, if it was paid into the bond, if the rates was paid, all that type of, and even the rent, we don't get involved with that calculations. We always say, and that's my advice to you as agents as well, to rather take a step back and say, you know what the terms and conditions are with the payments. The seller is responsible to, from their side, make sure that they see that the payments are coming in and send what needs to be paid, and the purchaser do their calculations on their side as well. And when it gets to that part to take transfer of the property, we then come back with everything and make sure that the figures actually align, because it's just too much. If it takes a year, 2 years, imagine all that payments, 24 months of payments that has been done. So try and take a step back there, as we do, and tell them, take responsibility for your own payments that are made and received and all that. And we sit around a table closer to time, because it does get complicated in that sense.
Yeah, it does. It does. And
Yeah.
unfortunately, it's not something that that we have time to deal with. But
No.
it's, I mean, it's that whole notion of, I'm going to pay your bond every month, right? And it's going to reduce the purchase price. So let's say your bond is 10,000 Rand, I'm paying 10,000 Rand, right? Sounds great. You're covering my bond. This is fantastic news. So now I'm buying the property. So let's say I bought it for R1 million. I owe, but the seller only owes the bank 900,000, right? I go, great, I'm buying it for R1 million. You only owe 900,000. Under a normal sale, that would be fantastic news. Now I'm going to pay 10,000 Rand a month towards your bond. So like you're good. You're never out of pocket. Sounds like fantastic news. What happens in the back end? So remember, your 900,000 that's due to the bank reduces, it increases every month by the interest, right? So very often, let's say it's 12,000 Rand. It increases by. Now you've contributed 10,000 Rand to cover a payment, as an example, or just about that amount. So let's say it's 10,000 Rand interest and you've paid 10,000 Rand, as a very simplistic example. The problem is that your purchase price has now stayed. Your outstanding bond has stayed at 900,000 because interest has been accrued and you've paid it off. So that's 900,000. But the purchase price on the seller has now reduced from R1 million to 990. So after 10 months, it's going to sit at the same amount as your bond, because your bond's going to go down very slowly from a capital reduction perspective. Because remember, interest is just under your capital repayment, especially on newer bonds. But your purchase price is going to go down by a solid 10 every month, and 10 and 10 and 10. After 2 years, you're probably going to be sitting on 800,000 outstanding on the purchase price, but your bond is still going to be somewhere around 850 outstanding, because it doesn't reduce at the same amount. So things like that are just things to consider. We do sometimes assist with that, just to kind of give you guys the notion of, listen, we need to be careful with it. The banks also take note of it, but it is something to consider, because you're going to go through this effort. You're going to, set up this whole deal commercially, and then we sometimes don't think about the consequences of that bond not reducing at the same rate as the purchase price. I see a couple of questions here, but we actually are going to get to them because we're actually going to get to that section now. So Alicia, I don't know if there's anything else you want to add. Can I? All right. So now the third part of this, opportunities and threats. So this is where now we're going to try be smart and clever. We're going to try and take these issues that we've just discussed, the fact that there's definite security for purchasers and sellers alike, and we're going to try find the opportunities in this that you guys can use to deal make. So it's, how do you make the deal happen? You as a property practitioner, how do you make it happen using the examples that I've given you? Are there any tax efficient uses for an ISA? So over here, I'll just give you one example. I'm not going to spend a lot of time on it, just an interesting little thing so you guys can also get your heads around that, because there might be instances where you could make the deal happen just because the seller might be able to defer the payment of capital gains, as an example. And the last one, are there alternatives? So that one in itself is probably a good 2 hour to 4 hour conversation. So I'm just going to list them, and then you guys can consider them. There might be even worth a follow-up topic, or whatever we'd like. So here we are. So the first one, opportunities and threats. Payment of a deposit is not a minimum legal requirement, albeit useful. I don't need to say much more about this. In my example alone, this was, this was clear. It was so apparent. Gave the guy 300,000 Rand. I basically saved myself having to pay any rental at all on that property because he needed the cash. And that for me is crucial. As an estate agent, same thing. It's not a minimum legal requirement for someone to pay a deposit, but come on, guys. You know as well as I do, if they pay that deposit and it sits in the attorney's trust account, you've got leverage for your commission. So it's useful, it's good, not necessary, but work with what you have. Alicia, anything on that?
Just saying that a deposit, I understand it's not a minimum legal requirement, but definitely if you want to negotiate your commission, it's very good to bring it in. And hopefully your purchaser then does actually have the funds to pay a deposit.
Exactly. So it depends which side you're on. If you're on the purchaser side, different story. Then both the Alienation of Land Act and the contract governed breaches. So I mentioned this before. The installment sale agreement is a very regulated contract. There's legislation. So the same way that the National Credit Act deals with credit agreements, the Alienation of Land Act deals with ALA agreements, right? Very consumer centric. We touched on this. So there's legislation that requires that the contract contain A, B, C, D, E, whatever, right? It's not a contract that we typically recommend that property practitioners off the bat go and try and negotiate themselves until they're very, very experienced. It's still one of those where there's no right template, there's no place to download. It's not a question of us just preparing one for you. It is very unique. There's certain maths that you need to consider. So the first couple, I would always use a specialist until you're very, very used to it. But just so you know, the contract has specifics that it has to contain. And when it comes to breaches and things like that, unfortunately, the contract makes provision for how to deal with breaches. It's not 7 days, it's 30 days. There's a way that you deliver the notices, things like that. So the contract has to be specific on this. The contract can have its own terms regarding other things. So whatever the Act doesn't specify, the contract can specify. But if the Act says 30 days notice, it's 30 days notice. The contract can say 35 days notice, but it can't say 7 days. It can't go less. It can't make it more cumbersome or burdensome on the purchaser, because remember, the contract is there to protect the purchaser. Early settlement of the purchase price is an option. So it's nice from the perspective of if if you're 6 months in, if you're 1 year in, or whatever the case is, and you decide that now, you know, you want to apply for that bond and you want to take it, you're allowed to settle it. The contract cannot not allow you to settle it, meaning that, yeah, you can't insist, the seller can't insist that the purchaser stick through the whole term of the contract, right? You'll see, the reason I mention that is in credit agreements, you sometimes find that that is the case because the credit provider makes their money from the interest. So they're not interested very often in you canceling the credit agreement. They want you to be stuck in it for 5 years, 10 years. So similar to this, if it's structured like a credit agreement, and I'll get to this in the next section, if it's structured like a credit agreement, you may find that a seller wants you to pay because you're paying a lot of money. So yeah, the legislation does say that the purchaser is entitled to settle early. And then, does the seller have to be registered as a credit provider? So I do see that this was asked, I think it was by Michelle.
Yeah, Michelle asked that question.
Yeah. So credit providers, any contract that defers the payment of a sum at a cost, right? So a supply agreement, a goods agreement, a services agreement, whatever it is. If you defer the payment, even as an estate agent, if you defer it and say, well, I'm going to allow you to pay my com off in a year, but I'm going to charge you interest because of it. Unless it's by court order or following a default. If it's a contract that you enter into ahead of time, it's a credit agreement. And it makes sense because you're giving the person credit, but now they're paying more for it. The service might have been 100,000 Rand, now they're paying 200,000 Rand because you've allowed them to pay it off over a year. That's the definition of credit, right? Now, yes, there's a lot of different scenarios where, for example, if I had to sue for commission and I charge interest on top of it, that's not what I'm referring to because that's mora interest. That's when you're trying to claim from a person that simply isn't paying. This is when I'm referring to a specific agreement that gives people leeway, right? So is an ISA a credit agreement? It can be. And this you need to be very, very careful on. If you're charging interest, so if the seller is benefiting from the delayed payment of the purchase price, you've got a problem because he needs to be registered as a credit provider. Because at the moment, the threshold for credit agreements is 0, meaning that any credit agreement above 0 Rand is considered to be a credit agreement and that the lender has to be registered as a credit provider if interest is being charged. If interest is not being charged, seller's okay. So the seller can charge rent. That's perfectly fine. And sometimes we find that the rent is enough because they're getting rent and they're getting the purchase price paid. And if the rent is good enough to cover expenses and you put a little bit of money in their pocket, it's all good. And remember, even if the contract is cancelled and somebody tries to claim back the purchase price, they can't claim back the rent because they did enjoy occupation of the property. So more often than not, this is not a challenge for me because I normally just say charge rent, the guy's in occupation, you're making enough money as is, do your calculations, figure out what goes towards rent, what reduces the purchase price, and you're good to go. However, if a person does insist on charging interest, they may need to register as a credit provider unless they fall within one of the exceptions in the Act. We can go into that. That's a whole other different story. It relates to the sum, being lent, whether, the person, the consumer, as it were, is a juristic person, whether they have a certain asset value or turnover. There's ways around it. I'm happy to have a conversation with you guys to explore ways around it, but just so you know, off the bat, assume that you'd need to be a credit provider until I basically tell you otherwise. Then, Alicia, I don't know if you have anything to add to that. You're good. I'm told that the agreement cannot be longer than 5 years. Is this true? Yeah, I'm hoping, well, Leonora and I debate over this all the time, so I'm sure you'll either be on her side or my side. This 5-year limitation is a bit of a strange one. I read the act differently to many other people. So, in fact, myself and Solna Stain were having a conversation about this, and she agrees with me. But then I approached other attorneys, and they disagree with me. This 5-year limitation is a weird one. Long story short, how long can a payment of the purchase price be deferred for? 5 years. The Act says 5 years. Certain attorneys, including Cliff Decker Hofmeyr, says 5 years. So you want to play it safe, keep it at 5 years and say at the end of year number 5, you're going to need to pay the balance of the purchase price. So think about this as a balloon payment. You pay installments every month and you get to the end, and all of a sudden there's this massive payment that becomes due. But you can use this time in order to fix your credit record and obviously reduce the actual cash that you need in the transaction. So if you're only getting bonds for like 80% or something along those lines, it helps that you've used the last 5 years to pay down the purchase price, because now you're applying for a 50% loan as an example, or 60% loan, because you've managed to pay 40% of the purchase price off. So that's great. 5-year limitation. Then we've had transactions where we've got a little renewal clause to say it's 5 years, but if we can't get that bond at the end of 5 years, we're basically going to novate this, and it's going to be like a new agreement at this purchase price, or and we're going to register it, or we're going to renew it. So there are ways of extending that 5 years and making it a little bit longer. Alicia, examples of this? You've also dealt with a few.
Yeah, no. So we have done an extension, but not after 5 years. I think it was like after a year or so. So that was a pure addendum that we just did to the agreement. And if I say addendum, this is more the kind of language that the agents understand. So my question to you would actually be, what if we get to the 5-year mark? Is it a new agreement, as you are stating, or is it actually, can you do an addendum as well?
I would argue, so it's a funny one, and I don't think anyone's ever pushed back, because remember, this contract isn't popular enough where there's Supreme Court of Appeal cases every week on it, right? There's a couple. And no one's ever addressed the question over what happens after 5 years. The deeds registry keeps this on record. There's an endorsement. So practically speaking, now you're going, well, the Act says 5 years. We put it for 5 years in the contract. There's been an extension, but the deeds registry hasn't removed it. So the purchase is still relatively protected.
Yeah.
At the end of the day, remember, it's still a contract, so there's still a binding nature. There's still binding nature to it. The law doesn't allow money to just fall through the cracks and people to keep money without receiving any benefit. That's undue enrichment. So the purchase is still well protected. Is it a brand new contract? I would say that it could be if it wasn't for SARS and transfer duty, because that starts getting complicated. Because now, what do? Do you cancel the previous contract, enter into a new contract, but at a reduced purchase price, or you apply the cash into the new purchase price and you repay transfer duty? So if you could do it in a way where in SARS there's a null effect, you could probably just enter into a new agreement. I don't see a problem with it.
Yeah, it's just the transfer duty aspect, actually. I would rather go the route of like an addendum-ish thing instead of doing a new agreement, just based on that fact, though. If transfer duty is not involved, perhaps you can then negotiate a new agreement. It is safe to say that the deeds office won't just take off that endorsement just because it's after 5 years, definitely.
Yeah, no, definitely not. And then there was a question regarding transfer duty. So yes, 6 months. It's always been the rule. It's still the rule. Transfer duty has to be paid within 6 months. So there's nothing we can really do about that, guys.
If it's after 6 months, it's interest pro rata until it is actually paid. So definitely when you do negotiate it with the client, is to make sure that the client does at least have transfer duty if he's buying a house or property over 1.1 million. Because remember, the transfer duty threshold also changed in March from 1 million to 1.1. So yeah.
And you don't want to prejudice the transaction. So as agents, what I'd suggest is you get onto a line with an Alicia and you go, okay, listen, I entered into this contract now. so obviously there's a cost associated with recordal of the contract.
Mm.
Bear in mind that a lot of you would be representing sellers. If the recordal of the contract, if the contract's not recorded, there's actual court decisions saying that the amount does not become due until it's recorded. So the purchaser is not in breach until the contract's recorded. And in fact, the purchaser may very well be entitled to cancel the agreement if the seller does not go and record. But the weird thing is the purchaser pays for the recording anyway. So there's no valid reason why the seller wouldn't actually go record it. So my suggestion is you draft the agreement, you go to an Alicia, you draft the agreement, you then in the agreement make provision for the purchaser to pay the purchase price, to pay the fees. So first off, pay the fees, right? Before we even waste our time waiting a couple of months and waiting for installments off the bat, even if the first installment's only due in 3 months, you pay the fees, pay the transfer duty, right? Keep that in trust. Keep that as something, because you don't want to go, oh, but it's only due in 6 months. We'll get the transfer duty in 6 months' time. And then now they don't pay transfer duty, but they're paying the installments. It's kind of this confusion. Our interest is accruing. What happens then? Then it becomes difficult later to take transfer. It's not worth it. I would rather be clean and say, fine, we can wait 6 months, but I'm keeping it on trust until we actually go ahead with it. So definitely like be very systematic about it. Michelle, so the exceptions, unfortunately, we're not going to have that much time. Let's see if we've got time at the end when we deal with the Q&A. In case we don't, you're also very welcome to contact me and we can have a chat about it. And Nicolene will give you my contact details and we can take it from there. But yeah, let's just mental note. We'll try to answer that question when we go through all the Q&As. Then next, there we go. All right. So a very small little example. Don't stress too much about this, but a nifty, I've experienced this on a couple of occasions, nifty way of convincing a seller that an installment sale agreement isn't all that bad. And sometimes comes down to what's the word? A capital gains tax. So in my tax practice, we actually looked at this in a couple of times through some sellers where they didn't have the funds right now. So a lot of the guys we deal with in my tax practice actually want to transfer properties to themselves, but let's say to a trust or a company or whatever the case is. But this would still apply if you're transferring it to a third party. So now you're selling the property and there's a capital gain, right? I think in this instance, sorry, so there's capital gain of 75,000 Rand. So in the first year, the only sums that accrue is 150,000 Rand, meaning that there's actually been a capital loss because you haven't paid the full purchase price. The full purchase price is, I think it was 250. So now you've only paid 150. So that means that there's still a loss. There's still a loss after the first year. SARS ring fences it. No taxes paid, gets carried over to the second year. So that means that whereas you're supposed to actually pay a capital gain from the sale of your property. So if I sold it today, there would be a capital gain of 75,000 Rand. But because I'm not expecting the full purchase price today, and the price only accrues in year 1, year 2, and year 3, you only actually start paying your capital gains towards the end. So you pay in year 2, 20,000, year 3, 55,000. So this isn't a tax saving at all, right? But it's actually just a deferral, because sometimes with these transfers, people realize they're going to pay a lot of money, and let's say the bond is quite high and they can't afford to pay it. Now they're worried they're going to get into trouble with SARS, or they're transferring to their trust, so they try and find a tax efficient way of doing it. This is a way of doing it where you do it over a couple of years, you pay it off, so that it starts becoming more affordable, more tax planning or a cash flow planning tool than anything else. And then the last thing in the section was to discuss, oh, sorry, I think my sound is breaking up. The last thing to discuss is the alternatives. When we look at installment sale agreements, the whole basis of our approach here has been to equip you guys with tools so that it makes it easier for you to be able to close deals. Now, installment sale agreements are one of the more common ones, alternatives that we deal with when it comes to estate agents. We try to give you guys a whole range of ideas on how to construct these deals, and then we help you cross the line with them, right? And that's why we're here. We actually jump in before the contract is signed, and we try and help. We try help in the process. But just so you guys know, and I wanted to throw it out there because this is definitely topics worth discussing going forward. Did you know that as estate agents, if you're brokering property deals, it doesn't necessarily always have to be sales, strictly speaking. We've worked with guys, for example, rent to buy we discussed, where there's an option, right? Option to buy at a later stage. You can earn your commission off the exercise of an option because you brokered that sale. Private bonds. There's seller financing options where I will transfer the property to you as a buyer, and I will register a bond against the property for the security of you paying me off, the same way that a bank would. That's a sale. State agents, you're entitled to your commission off that. Loans. So a lot of the times when we're dealing with investors, sometimes they go into deals where they lend money to an owner, or they enter into a JV with an owner, where they're going to try utilize these funds in order to do something to the property so that it can be sold at a later stage and profit can be derived from it, right? These JVs, these loans, these are still procuring deals. It's business brokering for all intents and purposes. It is definitely something that as estate agents, when dealing with property, you guys can start looking at. And then obviously your option agreements, like I mentioned earlier. So just things to keep in mind. Don't be closed-minded on the options that you guys have. Don't think that the only thing you're entitled to do is sell a property. You're deal makers. Look at it like a deal maker. Try and make a deal work, and then claim what you're entitled to, right? And yeah, Alicia, I don't know if there's anything you want to add to that. You're good. Cool. Then now we've got a bit of time for Q&A. We ran 6 minutes over. I did rush through the last few slides in fairness, but we do have a bit of time in our hands. Please, though, while we're doing Q&A and answering anything, I really appreciate if you guys would rate this presentation. Yeah, if you make a comment, that would be fantastic as well, but you don't have to. Just let us know what you thought. Let us know if there's anything that you'd like to hear from us moving forward, or let Nicolene know, but we'd really love your feedback. And obviously feel free to contact us if you have any questions. Our details are here. Or Nicolene would have them, so you can also contact her and ask her for it. So now we look at the questions. So Michelle, I kept yours in mind. So the first, so your question was the exceptions. I'm assuming that you're referring to the exceptions, National Credit Act, right? So the exceptions in the National Credit Act, the consumer is the protected one. If the consumer is considered to be sophisticated, which is actually an American term, a sophisticated consumer does not need the same protection as everyone else. In fact, those protection mechanisms cost money from a compliance perspective, so they're not interested in that at all. And that's for sophisticated investors. So now we look at the legislation, we try to figure out, well, what does our legislator consider to be sophisticated? So in terms of the National Credit Act, they look at juristic person. So the person borrowing the money being some kind of company or a trust that has 3 trustees, right? So that already they start looking at sophisticated, but it's not enough, because you have small businesses, or you have deals, for example, where a person is made to register a company to borrow funds, but it's actually for them personally. So the second protection mechanism is to say, well, sophisticated also needs to be a juristic person with an asset value. So asset value or annual turnover of over 1 million rand, right? So asset value, take all your assets, add them together, not without, don't deduct liabilities, just look at assets, or your annual turnover. So, that top line on your income statement, that's what we look at. So that is a sophisticated juristic person. National Credit Act does not apply. So let's park this one side and say that that is one example of an exception. Now, another example of an exception that not a lot of people know about is if the value of the loan is above a certain amount, so 250,000, and it's going to a juristic person, it's also an exception. Now, in the Act itself, though, there are certain deemed provisions where they say, look, it doesn't matter. None of that matters in these circumstances. But for the most part, and especially because installment sale agreements in the National Credit Act are only deal only with movables, when we're looking at this one, it's not actually very defined in the Act itself, meaning that the general rules would apply, meaning that very often you can get away with this exception if the person buying is a juristic person and the value of the property or the deferral, the credit itself, is above 250,000 Rand, which typically with property it is. But you need to structure it properly. And there can't be any, what's the word? You can't force someone to try fit or fall out of the Credit Act, because that's not going to help you. At the end of the day, if that person then later comes and cries foul and blames you and says, but the estate agent told me that if I buy it like this and I buy it like this, it would work better for me, then you're going to get into trouble. Because number one, you're not allowed to advise people of those legal things. You're not allowed to advise people to fabricate a scenario that's not real. So I typically stay very much away from that. If the person comes in with a company anyway, that's great. If a person doesn't, then I'd rather not charge interest in this agreement and rather make provision for everything through rental. Alicia, I don't know if you've seen any other questions or if you have anything that you want to discuss.
I have actually answered most of the questions that people have popped up. So mostly it was about costs and transfer duty. So I don't know if there's anyone else having questions with regards to that. I know a lot of people want to know as well, which I did answer, the costs. So the costs for registering the installment sale is different than the transfer costs because it's a fixed amount usually. So it's usually, I actually went back to look now because I mean I haven't done one recently, what the cost of, but about a year ago it was about just over 8,000. So I think it would now, with the fees going up, be anything between 8 and 10, I assume. So it's usually a fixed amount. The transfer fees is usually based on the purchase price, and that's also applicable once you get to that stage where transfer actually needs to be effected. It will be based on the purchase price, and there will be transfer fees involved as well.
And it's so the costs that we actually factored in here, it's quite funny. It depends on your experience. We actually have a package for some of our investors that know this as well as we do. So they go out, they've got the contracts in place, they've used it 100 times, they tick the right boxes, they've set up their business to be able to function with installment sale agreements, and all we do is they come to us and go, listen, do your job, do the recordal, right? That's actually quite a low fee, because then we just go to the deeds office, we record very little on our part, aside from obviously the actual conveyancing function, right? Because remember, conveyances nowadays, it's no longer a question of we go to the deeds office, we register, that's our job. We are on the phone with the municipality. We're on the phone with the purchaser. We're on the phone with the seller. We're giving updates to agents. We're trying to fix problems. We're sending out breach notices. So conveyances have taken a hell of a lot more, a bit larger role than the old traditional role, which was our job is to make sure it goes from A to B and the deeds office sees it. And so with this, if a person brings us a contract that's ready, we actually have a very small fee for it, because we're not expected to do anything but our traditional fundamental job. If they don't, and if there's coaching, and a lot of times it's coaching because you need to convince sellers. We've had to sit for an hour with the seller, an hour with the purchaser, draft the contracts. Then that's why there's a variation in price, because it's not just a question of registering, which is like 4,500 or 5,000 rand.
Yeah, it was about 4,000 in there. Obviously then like postage and petties and the deeds office fee. So that's round up about 4,500. That 8,000 rand one that I saw is when we actually negotiated the installment sale and drafted it.
Yeah, exactly. And the 10,000, if memory serves, actually has a coaching session where we sit down, we try to explain what or how one should negotiate commercially and actually go in. So so that's pretty much it. Alicia, is there anything you want to?
Nothing from my side. I think we've covered basically everything. I don't know if there's any more questions. I haven't seen anything else pop up here. So maybe we've covered everything.
Wasn't that absolutely brilliant? Do you think we should get them back to tell us a little bit more on the alternatives? What do you guys think? Rent to buy, private bonds, loans, all of those. So you can just give me a yes in the chat box. And please go and leave them a review. There are their details. If anybody needs other details, let me know. Or alternatively, Bruno and Alicia, if you want, you can just pop your email address in the chat box, whichever is one is best for you. And then, guys, this can be very profitable, but you need to use an attorney that knows what is going on. So if you want to go into this, you want more, give Bruno and them a call. They definitely will guide you through everything. And this is a great revenue, another income stream for you that other agents don't know how it works. And because it can be a little bit complicated, we tend not to touch it. So it's literally an untapped field for you to go out there and gain some business, especially in those areas where someone might be in trouble. And this is the way where we can help them out so that they don't lose everything. Bruno, Alicia, absolutely amazing. We love it every time you come. Bruno is now officially our favorite attorney, and every time he comes, he brings his power team with, and we just get so much value out of it. Thank you so much. And it looks like the majority of people would want to know a little bit more about the alternatives. So Bruno and I will have a chat and see when we can set that up for you guys. Thank you so much, everybody. We hope you have an amazing week, and we'll see you next time. Just remember, on the 14th of June, if I'm not mistaken, let me quickly double check for you. Is it the 14th of June? We have, let me just double check. Yes, the 14th of June, we have Bruno back with his team on the pitfalls, the OTP pitfalls, where we're going to talk about all the things that can go wrong in an offer to purchase. So don't miss that one. You can already register for it on the university events section. University events, you'll see it down there in June, or alternatively, we'll also be sending out email reminders closer to the time. Thanks again, everybody. Thank you, Bruno. Thank you, Alicia. We appreciate you.
Guys. Thanks.
Bye.